Hello.
Hello.
Yes. Mr. Freeman, can you hear us?
Yes, sir.
All right. All right. Well, I am ready to call the case. Well, you know what? We don't have a court reporter.
Judge, do we need to have Mr. Freeman on video? Well, he does have a unique voice. Be best.
I think if Mr. Rivera can identify
There
him
we
in
go.
the back, there we go. And there's Amanda. So we'll get ready. Anyone need to talk about anything before I call the cases?
I don't think so, Judge.
Sir.
All right. Amanda, you ready for us?
Be about 5 seconds here.
Okay.
I'm ready. Thank you.
All right, let's be on the record in two cases, those being 2018 TR 1996 and 2019 CR 1170, both captioned State of Kansas versus Reobert Freeman. Would the parties announce their appearances, please?
May it please the court, Your Honor, State of Kansas appears through Assistant District Attorney Mark Brinkworth.
Your Honor, Mr. Freeman appears in person on video with Counsel Vincent Rivera.
All right, we are here set down for a sentencing. And Mr. Rivera, you might get closer to your microphone or something. It's a little difficult to hear you. As I said, we're here for a sentencing. The record should reflect that back on February 26th, the parties appeared, at which time the defendant in the 2019 case changed his plea from one of not guilty to guilty. The court inquired and accepted that plea, ordered a pre-sentence investigation, and set it for sentencing today. I've received that PSI, and the critical findings are as follows. The primary offense of conviction is one of aggravated criminal threat. That is a severity level 5 person felony. The defendant's criminal history score was found to be that of A as in Adam. That would leave him with a presumption of prison and a presumed range of 122, 130, or 136 months. If he has to do that time, he'll be eligible for up to 15% good time credit and subject to 24 months of post-release supervision. The special rule number 10 applies in that he was on felony bond at the time of the offense. If he's granted probation today, it would be for a period of 36 months to community corrections. That is the sole count of conviction. I would ask you first, Mr. Brinkworth, did you have an opportunity to review the PSI? Any additions, corrections, or challenges?
Judge, I have had that opportunity, and no, I have nothing to contribute as far as adding or amending it.
Mr. Rivera, same question as to the PSI. Any additions, challenges, or corrections?
No, Your Honor, and I did review that with Mr. Freeman.
I couldn't understand that, Mr. Rivera. You said no and then something.
No, sir, I did review the PSI with Mr. Freeman as well.
All right. So, Mr. Freeman, your lawyer tells me he went over this PSI, particularly that criminal history worksheet, and you believe that it's accurate. Is that correct?
Yes, sir.
All right. Mr. Rivera, you filed a motion for a downward durational and dispositional departure. Would you like to be heard on that this morning?
Yes, Your Honor.
Please do.
Judge, this case has taken quite a while to resolve. I believe we were originally set for trial last April, give or take. Obviously, COVID hit. Mr. Freeman had been in custody then since the time of this offense, since October of 2019. Because of COVID delays, we finally got back in front of the court in August for him to be released. The court did grant him a bond at that time. This plea is a result of very lengthy plea negotiations. This was ultimately mediated in front of Judge Russell. I can tell the court that in coming to this agreement, all the parties were aware that Mr. Freeman would be criminal history A. We had a tentative criminal history check done January 15th 2020. That did come back with him as an A with 2-person felonies, and I think they had 6 aggregated misdemeanors. Obviously, ultimately, I think we came up with 12 aggregated misdemeanors in this case. I don't believe that additional criminal history significantly impacts the decision of the parties. Again, him being largely aggregated offenses with the 2 felonies. Your Honor, I've also attached Mr. Freeman's mental health report. I did get him evaluated in preparation for trial in this case. I believe the court's aware of what the findings were there. But I think most significantly is kind of what happened after we reached this agreement. And when I'm sorry, you got me?
Yep.
Oh, okay. When he was released in August, only a few weeks later, the mother of his child died from COVID. And so basically, in less than a month, he went from close to a year in jail to being out and being a single father. So right now, he is the only one taking care of his little girl. He does get some help from some family members. This allows Mr. Freeman to work full time. And with him having been out since August, it's my understanding that he has not had any kind of problems. He's remained, I believe, reporting to probation for the other case in this matter. So he has been on supervision since August. Judge, again, him being a single father now has really impacted his motivation and desire to do right. And I think that's evident from his behavior since he's been off supervision. So, Judge, we would request the court to follow the plea agreement.
All right. Mr. Brinkworth, I would hear your comments as to the defendant's motion for departure and anything else touching upon sentencing.
Judge, the state has agreed to recommend the downward dispositional departure and the durational departure, and primarily the reasons are what Mr. Rivera stated, which is that Mr. Freeman now has a daughter that he has to care for. So we were willing to give him this chance at probation. The underlying crime here is a serious one, Judge. It's not something to be taken lightly. I mean, they had to conduct a search of the courthouse for any potential bombs as well as the jail. So it is a very serious crime. But because of his daughter, the state is willing to give him this chance. But we're going to be pretty strict on that he's following with the requirements if in fact the judge or your honor does give him probation.
All right, thank you. Mr. Freeman, now's your opportunity to tell me anything you want me to know in mitigation of your sentence today.
No, sir.
All right. Mr. Rivera, do you know any legal reason why I should not now proceed to sentencing?
No, Your Honor.
All right. Well, Mr. Freeman, I'm going to follow the agreement here today, but I need you to understand that when I say I'm following the agreement, I'm not only granting you the things that you wanted out of it, but I'm also granting the things that the state wanted out of it. And one of the important things that they said in here was that if you have a motion filed that alleges any kind of new crime, new misdemeanor or new felony, that they're going to ask me to proceed immediately to, if I find what I need to find, to sentence you to that time in prison. So I need you to understand that. I will follow that just like I'm going to follow everything else. I'm not going to listen if I find that what I need to find as to the existence of those new charges. I wouldn't listen very intently to mitigating circumstances or reasons why I should not impose that. What you're agreeing to today is if you catch any cases like that in which there's probable cause, you understand you're going to be going to prison. So,
Yes, sir.
so I think it's very important that you understand that this is kind of not one of these agreements where I agree to follow it today, and then it's kind of done. Because the other stipulation in this agreement was that if you get any more cases, that you're not even going to seek reinstatement. So given that, I'm ready to pronounce sentence. I do find from my review of defendant's motion and defense counsel's statements today that there are substantial and compelling reasons to justify both a downward dispositional and durational departure. I will adopt as those substantial and compelling reasons those things set out in defendant's motion and made argument today by counsel. Given that, the defendant will be sentenced to the Department of Corrections for a period of 60 months. If he has to do that time, he'll be eligible for up to 15% good time credit and subject to 24 months of post-release supervision. I consider his application for probation, and that is granted to community corrections for a period of 36 months. As per the plea agreement, part of this case and the prior probation is that he get intensive outpatient treatment as indicated in his substance abuse evaluation. He's not allowed to consume any illegal drugs or drink alcohol during his probation and must notify probation officer of any medications prescribed by a licensed medical professional. He obviously has to report as ordered by his probation officer. He can't drive unless he's validly licensed and insured, and within a vehicle that has an ignition interlock. And those are in addition to the normal and standard terms of probation. So that's sentencing in the new case. My understanding, Mr. Rivera, is part of the plea agreement is that defendant stipulates to the violations in the TR case that he agrees that he's not going to get jail credit in that case, even though it applies to the new case, that the parties recommend that probation be reinstated and extended for a period of, I believe, a period of 12 months.
Yes, Judge.
To coincide with his new probation. Given that, Mr. Freeman, you understand that as part of this plea and part of this agreement, you would have a right to challenge the violations set out in the motion for revocation in your old case, but your lawyer tells me that you agree to those violations and want to go to disposition today. Is that correct?
Yes, sir.
All right. Well, I'm going to accept that stipulation, find him in violation in the TR case, reinstate his probation, extend it for a period of 12 months from today with all of the same qualifications that I gave in his new probation. All right. That leaves me to consider at this time costs and fees. I would hear party's statement on it. I'm kind of convinced, given Mr. Freeman's unfortunate situation and finding himself as a single father, that he needs to spend more of his funds towards taking care of his child. Mr. Brinkworth, do you have any objection to me waiving all of those things?
No, Judge. I believe that just the only thing that by Supreme Court law, I don't know if the court costs can be waived, but otherwise I think you can waive just about everything else.
Oh, I know I can waive court costs. Usually what can't be waived are like database fees and things like that, but he's already in the database. So yeah, I'm going to waive docket fees, supervision fee, attorney's fees. He doesn't have to pay the database fee because his DNA is currently on file. There is no restitution requested in this case. So, and look, I find for the reason of that, as Mr. Rivera said, Mr. Freeman was raising a child with his significant other who passed away from COVID, and now he's responsible for the care and raising of that child. I find that it would be a substantial financial hardship for him to be assessed those, so I'm waiving all of them.
Yes, sir.
All right. Mr. Freeman, as a convicted felon, it's prohibited for you to own or possess a firearm, certain kind of deadly cutting instruments like dirks, daggers, switchblades, basically knives that can be considered deadly weapons. Do you understand that?
Yes, sir.
All right. And you have 14 days from today to appeal anything you don't like about your sentence. You may be able to seek expungement after a period of time following successful completion of probation. Mr. Brinkworth, this is not a registration case. Is that correct?
That's correct, Judge.
All right. Anything else, Mr. Brinkworth, that I haven't covered today that you feel need to be covered?
No, Judge, I don't believe so. Jesse, do you need him to contact you today?
Well, I wanted to confirm with that TR case, that will also be following along with the new case for 2 community corrections, correct?
That is correct.
So he will need to contact community corrections following this hearing.
Okay.
All right. Mr. Rivera, anything else that I haven't covered today?
No, Your Honor.
All right. I'm going to, we will be